Now, if you look at the screen, Part 20 is Amendment of the Constitution. Part 21 is Temporary, Transitional, and Special Provisions. Part 22, Short Title, Commencement, Authoritative Text, and Repeals. Okay, we will be discussing on these three parts. Amendment of the Constitution, we will be studying about how the Indian Constitution is amended. And temporary, transitional, special provisions. Article 371A, the right that is given to the Naga people is contained in Part 21 of the Indian Constitution, Article 371A. These are temporary, these are special provisions, okay? And there are some temporary transitional provisions as well. Transitional, as you can see, is an obvious term, meaning the transition from pre-constitution era to post-constitution era. Some transitional laws are added here. And then short title, which states that India shall be called, this constitution shall be called the Constitution of India, a very short title, and so forth. So we will be learning each of them one by one. Now, these are the articles covered under each part. Part 20 contains only one article, Article 368. Okay, if the Indian Parliament wishes to amend the Indian Constitution, they do it based on the rules and procedure contained in Article 368. Article 368 is explicitly and exclusively meant for changing the Constitution. The Constitution cannot be changed, cannot be altered easily. Okay, there's a very special procedure which is mentioned in Part 20 of the Indian Constitution. And Part 21 will cover Articles 369 all the way up till 392. Part 21 will cover Article 393 to Article 395. Okay. Now this is Part 22 of the Part 20 of the Indian Constitution. Article 368 provides the constitutional procedure for amending the Constitution. Why? It enables Parliament to modify constitutional provisions and also respond to changing political, social, and economic needs. Okay, for instance, originally we had right to property and the fundamental rights, but because of the change in economic needs, the center felt like they need more power with regards to right to property, so that they can acquire property more independently with more power, and which is why they removed right to property as a fundamental right and then transfer it to Article 300A as an ordinary legal right. So that's one example of the central government's response to changing political, social, and economic needs. And then we also have some certain rights for transgenders, right? And the wave of transgenderism occurred only after the commencement of the Indian Constitution. Okay, so all these are required to maintain constitutional continuity, relevance in the present times. Okay, so again, if there's anything that goes against democratic governance, they change it with time. So it is also to preserve democratic governance. Now, the key principle of the Indian Constitution is it is neither rigid nor flexible, but a balanced combination of both. I mentioned about the federal feature of the Indian Constitution, the division of powers, the union list, state list, concurrent list, right? Union list, they have their own list. State list, they have their own list. And there's concurrent list in which both the center and the state can make laws on. But in case of the conflict between the two, it is a center's decision that prevails, which means it is flexible as well as rigid. Now this is why we need constitutional amendment. Social transformation, economic development, administrative reforms, judicial decisions, technological advancement, strengthening democratic institutions, and correcting institutional deficiencies. So these are the 7 points that you can use if they ask you a question as to why constitutional amendment is necessary. Okay. Now this is the procedure for constitutional amendment. Okay, so before anything becomes an act, it is initially introduced in the Indian Parliament as a bill. Okay, or in the case of Nagaland, it is introduced in the Legislative Assembly as a bill. Okay, bill is simply a document intending to be an act. Okay, so this bill, any bill that wishes to be any bill that intends to amend the Indian Constitution will be introduced as a Constitution Amendment Bill, and it is introduced in either house of the Parliament. What did we study about money bill? When it comes to money bill, it can only be introduced in Lok Sabha. Okay, but for constitutional amendment, it can be introduced in either house of the Parliament. And let's say, for example, it is introduced in the house of Lok Sabha. Let's say it is introduced in the house of Lok Sabha. The Lok Sabha will pass the bill first, okay, by special majority. What is special majority? 2/3 of the members present and voting, and then majority of the total membership of the house. Okay, more than 50% of the total membership of the house. So this is special majority, and once Lok Sabha passes the bill with a special majority, it is sent to Rajya Sabha. And the Rajya Sabha follows the same procedure of special majority. And once it is passed by the Rajya Sabha, it is sent to the President in instances where the state isn't affected. But in instances where the state is affected, it will need state ratification. Now, what is state ratification? A state ratification, for example, let's say it's a law, let's say we pick Article 239A. It is the power of the Parliament to create Council of Ministers. Okay, that's not the case where state ratification will be required. Let's take Article 162, the extent of the state's executive power. So Article 162 under Part 6 of the Indian Constitution contains the executive powers of the state government. Okay, so the state cannot change the Indian Constitution. Only the center can. So in that situation, when the center tries to change when the center tries to change Article 162, the extent of the state's Nagaland's executive power, it will need the approval of the state. Okay, but in any part of the Indian Constitution where the state isn't affected directly, it is directly sent to the President before while skipping state ratification. State ratification is only needed in cases where the state is directly affected. So if Article 162 is going to be changed, which is about the extent of the state's executive power, once it is passed by Lok Sabha and Rajya Sabha, it will go to the state. The state will ratify it. Now, what is state ratification? Nagaland will pass it by a simple majority. If majority of them agree on the bill, it will be passed. So it will be counted as one state said yes. Okay, how many states do we have here in India? We have 28 states. Okay, so at least 14 of them need to say yes. Right? 14 of them need to say yes. So that's the 14 states need to say yes with a simple majority. Okay, that's called state ratification. Now, once it is done, once the state ratification is done, it is sent to the President for his assent. Now, in the case of constitutional amendment, the President cannot withhold his assent. Okay, he is obligated to directly give his assent. He is not allowed to withhold. He is not allowed to send it back for reconsideration. He is not allowed to convene a joint sitting of the Indian Parliament in case of a disagreement between the two houses. Directly assent duole lage when it comes to constitutional amendment. Okay, so no joint sitting is allowed. The President cannot withhold assent. Now, introduction of the amendment bill. A little bit in detail. The bill was introduced, right? The Constitution Amendment Bill. It may be introduced in either house of the Parliament. It may be introduced by a minister or a private member. It doesn't necessarily mean it has to be introduced by a minister. Okay, it can also be introduced by a private member. What did I say about private member? These are members of the Parliament that do not hold any kind of ministerial post. A simple member of Parliament. Okay, our Superman is also a private member. Because even though he's a member of Parliament, he doesn't hold any portfolio. So if you do not hold any portfolio and you are a member of Parliament, it means you are a private member or a minister, and they can both introduce the Constitution Amendment Bill. It does not require prior permission of the President. These points are very important, okay? since our upcoming prelims is going to be conceptual based, these points are very important. Now, voting. Each house considers and votes on the bill independently. Lok Sabha will vote on the bill separately. Rajya Sabha will vote on the bill separately. Important. If one house rejects the bill or the house disagrees, there is no provision for a joint sitting under Article 108. A joint sitting is contained in Article 108. We talked about that. So if one house rejects the bill, if Rajya Sabha rejects the bill, then the Constitution Amendment Bill will be rejected. Okay, it will cease to pass. It will cease to exist, and they need to reintroduce it again. And they'll go through the same procedure again. If there's a deadlock, there's no gathering together of Rajya Sabha and Lok Sabha. In other cases, there is. Okay, but here, for example, financial bill, if there's a disagreement between Lok Sabha and Rajya Sabha, the president may convene a joint sitting to solve the issue. But here, amendment, if Rajya Sabha says no, it's a no. Now, special majority. A constitutional amendment bill passed in each house separately by, this is called special majority. Always remember it, a majority of total membership of that house, a majority of not less than 2/3 of the members present and voting. 2/3. Okay? Let's say there's 90 people, 2/3 would be 60. Right? So 90, 2/3, it is divided into 3, 30, 30, 30. Out of 30, 30, 30, 2, which means 30 plus 30, 60. Right? 2 out of 3, 2/3. Okay, that's the meaning of 2/3. This is known as special majority under Article 368. Now, why do we need special majority? To ensure that constitutional amendments receive broad parliamentary consensus rather than a simple political majority. Okay, simple. It is much more difficult to achieve special majority than it is to achieve simple political majority. Simple majority means majority of the members present and voting. Okay, it's very simple. But here, total membership and then 2/3 of the members present and voting. Which means if we talk about simple majority, out of 90 MLAs, we only need the vote of 45, 46. Iman ekla lagi do. Ulibe yadi do 60 lagi. 2/3 means. You understand, right? Majority half la opor de. Now, Article 368. The President's assent. Once the constitutional amendment bill has been duly passed, it is presented to the President of India, and the President must give assent. The Constitution stands amended from the date of assent. Okay, once the bill is passed by both the Lok Sabha and Rajya Sabha, it is presented to the President of India, and then the President must give his assent. And when we talk about constitutional amendment bill, it is passed on the day in which the President gives his assent. Okay, that's the day that's regarded as the passing of the bill, the date of passing of the bill. Now, important points. The President has no veto power over a constitutional amendment bill, which means he cannot withhold the bill. He can withhold the bill for other cases, but he cannot withhold the bill with himself. In case of constitutional amendment bill, he is obligated to pass the bill. The bill cannot be returned to the Parliament for reconsideration. So, in other words, the President has no power and he must give his assent. That's the only choice he has when it comes to amending the Indian Constitution. Okay. Now, these are the types of constitutional amendment: simple majority, special majority plus state ratification. Okay. So, for simple majority, ordinary legislative powers; special majority, Article 368; special majority plus state ratification by half the state legislatures. Now, simple majority means no 368 amendment. Okay, any article 2, 3, 4, these do not form part of the constitutional amendment. Now we're talking about the amendment of the Indian Constitution. So every article that's changed must be a constitutional amendment. No way. But why is it mentioned no 368 amendment? It is not considered a constitutional amendment. Why does it say that? So there are certain provisions. Okay, let's say Article 2. The Parliament may, by law, admit into the Union or create states as it thinks fit, new states. So, paharla manu kando, they can just include it without constitutional amendment. It does not amend the core feature of the Indian Constitution. It only adds to this. Okay, so notun country kan anu guledo, it is not considered a constitutional amendment. Constitution change pranay. We'll give you more examples here. Simple majority amendments. So this is one example that I've given you. Admission or establishment of new states, Article 2. Formation of new states, alteration of boundaries, Article 3. Abolition of creation of legislative councils, Article 169. Citizenship provisions, Article 5 to 11. So these are not considered constitutional amendments, which means these are not considered as changing the constitution because the core nature isn't changed. Okay, the core nature of that article isn't changed. Only the specifics of it, only the nature of it. And every time there's a simple majority for certain parts of the Indian Constitution, in that article there will be a mention that this shall not constitute a constitutional amendment. Okay, so any article that mentions it is not considered a constitutional amendment, then it comes under simple majority. But the rest of the articles are all constitutional amendments. Please remember that. Now, you guys might be confused in the future, which is why I'm clarifying it very clearly. Admission or establishment of new states, Article 2, it says that the Parliament has the power to establish new states. Now that can never change, right? These are features of the Indian Constitution. These are articles in the Indian Constitution that doesn't make sense if it changes. No one will even change it. Kun pakla bhi change no kro do. To utu change no kro itu karni utula bithor de ki anule ase do. To tala core feature to hotai same thakibo ase. Itu karne it is not considered a constitutional amendment. It also gives the Parliament more power. For example, if we wish to acquire a territory of Pakistan, okay, if we wish to acquire a territory of Pakistan, and let's say Pakistan occupied Kashmir mon loise. So in order to utula ola pahar babi loise, so that's the creation of a new state, right? New state. So utu new state create koram de. What if it is considered a constitutional amendment? Ekta process lampa ekta jabo our parliament de. Utu lampa process itan yes na no go na jine. And yet time bi chai na ekta munduk ase. To territory natun do so mono agree do. India bi tangor ho gele. We all agree. We all like it. No. To utu situation de parliament but directly utu natun state to incorporate proper India de. And that will not be considered a constitutional amendment with the full discretion as a parliament. So they give them more power as well. It is not considered a constitutional amendment. Okay, you can go through the rest of the articles when you go back home. These are simple majority amendments that are not considered constitutional amendment. No, baki sopi special majority amendments, but the rest of the Indian Constitution is considered a constitutional amendment. But there are two types of constitutional amendment. One is special majority amendments. Two is special majority plus state ratification. Okay, now let us first study special majority. Fundamental rights, DPSP, all provisions not covered by other two categories. Fundamental duties, provisions relating to the judiciary, distribution of legislative powers. Now if you look at it, you don't need to know the key karne as a special majority. It's just rest of the articles of the Indian Constitution where the state isn't directly affected, right? And it's just the rest of the Indian Constitution where the first simple majority isn't contained. Special majority amendments, and you can only understand it once I explain the next page. Special majority plus state ratification. Now let's talk about election of the president. How is the president elected in India? Which votes are included in the election of the president of India? The votes of the parliament, Rajya Sabha, Lok Sabha, as well as the votes of the MLAs here. Or let's say election of Rajya Sabha. But first let's see the election of the president. The president though it needs the vote of the method of election of the president is single transferable vote, right? And then the election of the president is the voters of the election of the president are members of the parliament as well as members of the legislative assembly of every state. So this article in particular, if the central government were to change it, it affects the states directly. It affects the state's power because even the state is involved in the election of the president. So in that instance, let's say Modi ji wishes to change Article 54 and 55 with regards to the election of the president. So if he introduces a new law saying that the votes of the MLAs will not be needed, okay, it means it is directly affecting the states. So in instances where the states are directly affected, it needs special majority in the parliament as well as state ratification. So Mohanpi vote kuro, Assembly vote kuro, Tripura vote kuro, all the 28 states will vote, right? And once it reaches majority, out of 28 states, majority would be 14 and above. 14 above 14. 14 means middle de udala opore. Vote power lage. Ina hoise koile ikla utu change ko para. Noile to this particular article cannot be changed if all the states are against it. So this is done so in order to protect the power of the states, in order to protect the sovereignty of the states, in order to protect the federal nature of the state. If state ratification is not required, the center has the power to take away all the powers of the states, right? So that is why special majority plus state ratification. Now we learned about simple majority, we learned about special majority plus state ratification, and these special majority amendments are all the amendments that are not mentioned in the other two. This is the most common, almost 90% of special majority amendment. But only in instances or cases where state is directly affected, yadi special majority plus state la permission lage, or simple majority labi ekta thage, which is mentioned directly in all these articles that this shall not be considered an amendment of the Indian Constitution. Gonna Article 2 de be likhinas de, and the rest of the articles are mentioned. And there is one Article 169, creation or abolition of legislative councils. Now, if you look at it, abolition or creation of legislative council, why is it not considered a constitutional amendment? Because constitutional amendment, for example, let's say the state of Telangana has legislative assembly and legislative council. Okay, tahan legislative council to remove Gromunjai. Na, to tahan vote Growa. The Lok Sabha, the legislative assembly of Telangana will vote on the removal of legislative council, and by a special majority that will be removed. Okay, and then it will be sent to the center. With the center, the center will make changes to the Indian Constitution. But it is not considered a constitutional amendment. Kile, kule the ekta single state la khesi asido. Aro already passed korishe state te. So why does the center need to go through again another special majority? Because of the state la asido. So there are various reasons, okay? But these are simple majority amendments of the Indian Constitution. And if you're ever confused, you will, once you go through the Indian Constitution, you will find that in all these articles, it is directly mentioned that these changes shall not be considered a constitutional amendment. Okay. Now, state ratification process, the bill is passed by Parliament. For example, the election of the president, the rules for the election of the president. Let's say they're trying to change it. The bill will be passed by the Parliament with special majority. The bill is sent to the state legislatures, and then they need to get the majority of the states' votes, and at least half the states must ratify by simple majority in the legislature. And once it's done, the bill is sent to the president gives his assent, and the constitution is amended. Okay, very simple process, right? State ratification process. Now this is the basic structure doctrine. We are done with the three types of amendments: the simple majority, the special majority plus ratification of the states. Okay, that's all about Article 368. That's all you need to know about Article 368. But there's one additional point: basic structure doctrine. Now, the Supreme Court mentions that the parliament can make changes to the Indian constitution. The parliament can amend the constitution, but it cannot amend the Indian constitution in such a way that the constitution stops being democratic, the constitution stops being republic, and so forth. Okay? So these are the elements of basic structure that the Indian government cannot take away, that the union government cannot change. The supremacy of the constitution, which means the constitution is above everything. That can never change. The republican and democratic form of government can never change. The republican and democratic form of government can never change. The secular character of the constitution can never change, which means freedom of religion. The separation of powers between the union and states can never change. Its list may change, but the union and the state will always have a federal relationship. Okay? And then the unity and sovereignty of India can never change. The center cannot amend the constitution in such a way that Assam and Nagaland fights against each other. Okay? And the judicial review individual freedom and dignity of individuals can never change. They cannot take away our individual freedom and dignity, and judicial review will always be there. In case they amend the Indian constitution, the Supreme Court can revoke that, can cancel that, can delete that, can reject that. Okay, that's judicial review. The judiciary will review the constitutional validity of the act passed. And rule of law will never change, meaning everyone should follow the law. No one is above the law. The harmony between fundamental rights and DPSP also will never change. The harmony between fundamental rights and DPSP. Okay, directive principles of state policy. Which means one is neither above the other. Okay, one is neither above the other. For example, what's better for the union? What's better for the union is DPSP, let's say the fundamental rights and DPSP, maybe sometimes in cases they might prefer DPSP over fundamental rights. Sometimes there's conflict between the two, okay? And whenever there's a conflict between the two, sometimes the union government argues that that article is mentioned in DPSP, which is why it did that. But then some people will say it affects of fundamental rights. Which is so inigala situation there, taijun harmony thake. One isn't chosen over the other. We always try to find a compromise between DPSP and fundamental rights. Okay. Now, Kesavananda Bharati case. This is the most important constitutional case in Indian legal history. Kesavananda Bharati case 1973. Always keep it inside your head. This is the most important constitutional case in Indian legal history. Any person who has ever gotten through NPSC, I do not know a single person that does not know Kesavananda Bharati case. Okay, everyone knows that, and you should know it as well. The most important constitutional case in legal history. The bench, it was a 16-judge constitutional bench. Largest ever. 16 judges were seated and then were made to vote upon various issues. And the verdict was a 7-6 majority. 7 voted against, 6 voted against, and 7 voted for. Okay, whatever the Supreme Court established. Now, it held that the Parliament has wide powers to amend the Constitution under Article 368. Whatever I explained earlier, that was declared in Kesavananda Bharati case. The Kesavananda Bharati case, the Supreme Court says that the Parliament has wide powers to amend the Constitution. The Parliament has the power to make changes to the Constitution. However, the Parliament cannot change the basic structure of the Constitution. Okay? And they also say that the power to amend, change the Constitution is not a power to destroy the Constitution. So, this Kesavananda Bharati case, its significance, you might be asked in the exam, it established the basic structure doctrine. It limited the Parliament's amending power, and it remains the corner of Indian constitutional law. These are the 3 points that you can use in your examination. Another is the Minerva Mills versus Union of India. Now, I talked about Indira Gandhi, okay, in the 70s. She was despotic. She was very aggressive in her rule, in her governance, and in 1975, I talked about how the Supreme Court, declared that the election, her election to the seat of the Prime Minister was not conducted properly. There were some malpractices in the election. The election was rigged. Okay, it was proven. So, at the time there, let's see the validity of, the issue was the validity of 42nd Amendment Act, which gave Parliament unlimited amending power. and it also part judicial review of constitutional amendments. Now, I discussed about that a few days earlier, okay? What was 42nd Amendment Act? What was Section 55 of 42nd Amendment Act? The Section 55 of 42nd Amendment Act of 1976 showed two features. It gave the parliament, which means Indira Gandhi, unlimited amending power. Indira Gandhi and her government, unlimited amending power. They can amend the constitution, and then the judicial review, it also says that it cannot be questioned in the court. Which means, what did they aid? Again, what did they aid? Why did they need that? It aided that the election of the prime minister shall not be questioned by the court. Which means 1975 the election lushe Supreme Court kusal ja apni election to rig taze. To tai Indira Gandhi ra amendment 42nd amendment bitor thal dise section 55 ge. The parliament, moi aromala council of ministers, and then my party has unlimited power to amend, make changes to the constitution, and the judiciary cannot question it. Imondak thalio parise Indira Gandhi. And so, in the Minerva Mills versus Union of India case, 1980, in the Minerva Mills versus Union of India case, 1980, what did the Supreme Court do? 4 years later, it struck down Section 55 of 42nd Amendment Act. Okay, Section 55, utu wala do Indira Gandhi declared wala utu struck down court ishe, and then it also held that the Parliament cannot expand its amending power to destroy the basic structure. The Parliament cannot destroy the basic structure, and it also reiterated the statement that judicial review is a basic feature of the Indian Constitution. Every constitutional amendment is subject to judicial review. No one can escape the review of the Indian judiciary. Okay, and it also provided the harmony between fundamental rights and DPSP. Okay, so you understand. I hope you understand the Minerva Mills versus Union of India. So just give you guys a background of what happened in the 1970s when Indira Gandhi was in power. 1975, the Supreme Court accused Indira Gandhi of election misconduct, and because of which she introduced Section 55 in 42nd Amendment, which states that I have the full power, me and my council of ministers have the full power to amend the constitution, and no one, not even the court, can question it. And in 1980, Minerva Mills versus Union of India case, the Supreme Court struck down, okay, that case. Now, why is it called Kesavananda Bharati case? Why is it called Minerva Mills versus Union of India case? Now, it's almost like you going to the Supreme Court for a case, okay? And then let's just pick one. Mandilong, okay, he goes to the Supreme Court, he submits the case, and utu Mandilong versus Union of India. Let's say yedi tangor chemical plant ekta ase Nagaland de, hingna pura rivers kan Thansari river do letra ase already holibi aro letra court isuguna Supreme Court judge de. Supreme Court jaigina do Mandilong versus Union of India case, particularly to Kuradam de Mandilong will come up with various articles, fundamental rights, TPSP, Kiki kan anu the tai. I have the right, this and that article, this and that. Udu time de decide Kuralaze. The case is different, but for every case, Supreme Court can be udu change kro lage na, udu change kro lage na. Ina gonna change Kuralaze de. So it doesn't mean Minerva Mills versus Union of India was the case that discussed, that decided, was the case primarily for striking down Section 55. No, the case was different. Minerva Mills to the mill as do. Tahan bi ekta issue garni jala ase, but utu time de Supreme Court pra decide kurise. Manika Kandila case bi. Now it gave the biggest interpretation of Article 21. Manika Kandila case bi kusido. Manika Kandi versus Union of India. What happened? Tala Indian passport to luilishe. Regional passport officer ba. Now Manika Kandi went to the Supreme Court saying that she has the right to go abroad, which is why the Supreme Court inserted right to go abroad as part of Article 21, and it also inserted various other lease. There's a lease, okay. So iningala na ekta thage. So Minerva Mills versus Union of India case to be, it was a different case, but in that case the Supreme Court made the decision about Section 55 of 42nd Amendment. Okay. Now we have come to the end of amendment of the Indian Constitution. I hope that all of you will remember the simple majority, which is not considered a constitutional amendment, even though it makes changes to the Indian Constitution. It doesn't change the original structure, the basic structure, but it only makes changes to the details. Okay, new states, new union territories utan ai regole chai regole lage na. It's just a simple majority. Yadi eko security issue nai special thago lage boi na. And then we have the special majority for all the articles of the Indian Constitution. But in cases where an article affects a state, we have special majority plus state ratification. Okay, these are the three types. Always remember it. Now we move on to part 21 of the Indian Constitution, which will also contain Article 371A. Okay, for given to the Nagas. Now it covers Article 369 to Article 392. Now, what was the purpose? To address specific regional, historical, and transitional needs of various states and union territories at the time of their integration into India. Okay? Temporary, transitional, special provisions. Key categories: temporary powers of the Parliament, Article 369. Special status provisions, Article 371, 370, Jammu Kashmir, and special provisions for specific states, Article 371 to 371J. Article 371A be itu pitodi as a special provisions for specific states, Article 371A. Okay, and then the transitional provisions, Article 372 to Article 392, which is not too important because transition time there. Well, once India became independent, some transitional laws were needed, some flexibility were needed. There were laws stating in the previous classes I mentioned about a law that states that laws related to taxes pre-constitution era shall continue to be in force temporarily because ek purpose of change condition no hobo so these are special provisions. These are the key categories. Now these are the states with special provisions: Maharashtra, Gujarat, Assam, Nagaland, Manipur, Andhra Pradesh, Telangana, Sikkim, Mizoram, Arunachal Pradesh, Goa, Karnataka. Now in this, you in Northeast, Assam, Nagaland, Manipur, Mizoram, Sikkim, and Arunachal Pradesh. With special provisions. We will learn about that later on. Now, as I've mentioned, yes, this is Article 370. Okay, let's talk about Article 370. This Article 370 is for Jammu Kashmir. It is no longer in existence. Okay, the states, the Jammu Kashmir Reorganization Act of 2019, right, separated Jammu Kashmir into Ladakh and Jammu Kashmir. Now, I think I mentioned about that in our previous classes. So, utu time de remove Kordishe. Okay, remove Kordishe. Utu 370 special power. Now, special power there's a lot of special powers which I don't think it's necessary for me to explain everything, but Jammu Kashmir had its own constitution. Okay, a very interesting fact. It was still part of India, but again, it also had a mini constitution. The kind of constitution that NSC and IM is demanding right now. Only defense, external, and communications apply to Jammu Kashmir. The rest, apply no. They had their own constitution with regards to education, health and family welfare, and so forth. Only defense, external affairs, and communications apply to Jammu Kashmir. Union laws. Other union laws require concurrence of the state government. Utu apply groguledo state government law permission lagi. Article 1 and Article 370 itself apply to Jammu Kashmir. Okay. Now, what is Article 1? Article 1 says that India shall be a union of states. In that case, even Jammu Kashmir should be part of, should be a union of states, right? Now, this point states that it is a union of states, but it is not only a part of Article 1, it is also a part of Article 370, mini constitution ekta thakishi. Okay, but that doesn't mean it is not a part of India in a Goase. Now, residuary powers rested with the state, again, residuary, which means in cases where there is a conflict, if it's not mentioned in the state list, union list, and concurrent list, the rest is considered residuary. So, it rested with the state. Okay. Fundamental rights applied with modifications. Again, fundamental rights was uniform for the entire country except Jammu Kashmir. Directive principles did not apply. Again, directive principles did not apply. Kile union law ministers they have no power over Jammu Kashmir. Jammu Kashmir law nijo law MLAs can power to do whatever was needed to do. The president could not declare financial emergency in Jammu Kashmir. Again, financial emergency for a country. It has never been declared, but if it had ever been declared, Jammu Kashmir would not have been a part of the financial emergency. Imandak autonomy thakise. Because ekta beshi disputed area ekta ase to Jammu Kashmir region to. A good chunk of the Kashmiri people wish to be a part of India. A good chunk of the Kashmiri people wish to be a part of Pakistan. And at that time, it was necessary to appease to the people, to impress the people, right? Itu karne itu provisions kan 370 utai dise. But India though adat hui jaisi to. They are now part of India. India like benefits can enjoy grace, and they also wish to be a part of India, which is why 2019 they utu 371A remove kodise. And now Jammu Kashmir, all the constitutional laws of India applies to Jammu Kashmir. Okay, that's the only thing that you need to know about Jammu Kashmir. And this is the appropriation in 2019, the constitutional order. So now all provisions of the constitution applies to Jammu Kashmir. 370 is rendered inoperative, and there was one article, okay, Article 35A. With the Article 35A there, it gave the power to Jammu Kashmir to decide who the permanent residents are. That became a very heated issue because Jammu Kashmir did not allow foreigners to, buy lands in Jammu Kashmir, and there were lots of issues, okay. It gave like full power to the Jammu Kashmir legislature, the MLAs of Jammu Kashmir, the government of Jammu Kashmir to decide who the permanent residents are and who are not the permanent residents. So Jammu Kashmir la land issue ulai thakise. It will be removed for Article 35A and Article 370A by the constitutional order in 2019. Okay. Now Article 371A, 371 special provisions for Maharashtra and Gujarat. I will not explain that. You are not going to need it in the exam. You just need to memorize 371A, Maharashtra and Gujarat. That's it. And 371A, you will read in detail in the Nagaland class, Nagaland lecture. Okay, the teacher, the faculty will teach you everything in detail. All you need to know is that it gives us religious freedom with regards to no act of parliament shall apply to Nagaland. No act of parliament shall apply to Nagaland in respect of religion or social practice of the Nagas, Naga customary law and practice, administration of civil and criminal justice involving decisions according to Naga customary law, and ownership and transfer of land and its resources, unless the Nagaland Legislative Assembly so decides by a resolution. The real lahati kiman power as a babina. Ituan eku Nagaland anyo na pare without the resolution of Nagaland Legislative Assembly. So utu ase. These are the 4 points. Okay, the religion, custom law, customary law, and then civil and criminal justice, ownership and transfer of land. Utu charter points as they mentioned in Article 371A. Now the governor's special responsibility. Utu Puila important with respect to law and order in Nagaland, the governor shall exercise individual judgment, but it has a very historical context because this was linked to Naga Hills insurgency situation. Bitor mane beshi serious thaganam la special responsibility thagise. The governor could act in discretion as long as internal disturbances continue. No, it is no longer in existence. It is in existence, okay. But since we have a ceasefire agreement, normal as it is. But once a ceasefire agreement ceases to exist and internal disturbances continues, the governor could act in his discretion here in Nagaland. So this is a special power. A friend of mine was asked this, okay, in the NPSC interview. So they could ask you the governor's special power, special responsibility here in Nagaland. Okay, it is related to law and order in Nagaland, and the special power of governor is that he could act in his discretion if the internal disturbances in the state continues, and that's a special responsibility that you can mention in the NPC interview. Now, detailed analysis. You can go back home and you can take a look at it. Okay, I've made these notes for you guys. Article 371B and 371C. 371B Assam Aze, I will not explain that. 371C Manipur Aze, I will also not explain that because it's not necessary for you guys to know. And Article 371D, E, so forth. I will also not explain that. Article 371D, itu both for Andhra Pradesh and Telangana ase. And then Article 371E, Central University in Andhra Pradesh. I will also not explain that. You guys can check it yourself. And yeah, and even Article 371F, Sikkim. It will be, I will skip that for Sikkim. G and H, Mizoram and Arunachal Pradesh too. I will skip that. Goa and Karnataka too. I will skip that. But you guys can go through it. Okay, it's very simple to understand and detailed. But they're never going to ask you about all the constitutional provisions of Goa and Karnataka. 99.9%. They told me 99.9% germs removed for 100% not take it. So to they be 99.9% sure that utan na iwo. Many things to study na. Unnecessary kind of transitional provisions. Okay. Now these are transitional provisions, pre-constitution and post-constitution. A lot of them, almost all of them are no longer in existence. Temporary power of the parliament, Article 369. The parliament could legislate on matters in state lists for 5 years from the commencement. Again, expired in 1955. Take commencement 26 January 1950. The commencement of the Indian Constitution. For the next 5 years, the parliament could legislate on matters in the state list. The developments can anala time as well. State or parliament majude enemy thagala time no. The state they needed the expertise, they needed the skills of the central government, which is why the central government ba loigina state list for the next 5 years ki implement gorla se university set up railway station set up ki sub 5 years they plan banai dishe. Okay, it was necessary. And 370 Jammu Kashmir, again with the transitional provision to be removed. We studied, we covered it in the previous slide. And 371, we also covered it in the previous slide, special provisions for states. 371 A, B, C, D, E, F, G, H, and so forth. And 372, continuance of existing laws. Again, like always, all laws in force immediately before the commencement of the Constitution continue in force until altered, repealed, or amended. Some laws were needed even after the Indian Constitution came into force, so it will continue to exist. I talked about the jute, export of jute products in West Bengal, Bihar, and so forth. The export product, ekta economy hui jise. Ek parba ito do duties kan custom duties kan central ba low gole do. All the specifications, all the processes, technical knowledge kan bisi lagi do. Ek parba pura change korona bro. It will remain in force, and then slowly but slowly change ho inala na. That's what transitional provisions are all about. Okay. Now Article 372A, power of president to adapt laws. The president could adapt laws for states formed after reorganization. Again, it will be for transitional. And Article 373 to 392. Again, preventive detention orders under existing laws continue. Preventive detention orders under existing laws. Existing laws means before the commencement of the Indian Constitution. Okay, the judges of federal court existed before the commencement of the Indian Constitution. Supreme Court came into being only in the year 1950. Okay, before that it was called federal court. So federal court judge they became Supreme Court judges. Okay, again for transition, not important. High Court judges continue in office. There were high courts. Now high courts of Madras, Calcutta, Bombay. These judges could continue in office even after the Constitution comes into force. Purana Khan employees kan garne ase before the commencement of Indian Constitution. Comptroller and Auditor General was in office before the commencement of the Indian Constitution, and so forth. Okay, so forth. Most of these provisions have spent their force, become obsolete at the moment. Okay, so but they remain in Constitution as they have not been formally repealed. This is why a lot of complaints are made to the central government by lawyers and advocates, complaining that all the unnecessary provisions should be removed at one go. It's very messy. Ito ang nalagi ko ita. Lipitan remove Quran. They always like pusa khole focus kore thaki na. Constitution dan sapa guro lagi do, dan amend guro lagi do. Masala do. Lebi ina letra rakhi dia asu ta na. Aru mohon ki ulta tuk mon puro lage to exam garne. Yeah, part 22, short title, commencement, authoritative text and repeals. So we covered part 21. We studied about Article 371A, we studied about Jammu Kashmir and so forth. Now we will move to part 22, short title, commencement, authoritative text and repeals. Okay, this is the final part of the Constitution, deals with the official name of the Constitution, short title. La meaning do as they. It says that the Indian Constitution will have a title, the Indian Constitution. That's it, a very short title. Commencement of the Indian Constitution, 26 January 1950. Authoritative text in Hindi, would be Purva, and then the repeal of either constitutional instruments would be Purva. Now, these are the articles, okay, 393, 394, 394A and 395. Now, let's take a look at 393, short title. It only mentions that the Constitution may be cited as the Constitution of India. Itu pura kitab la naam diya ase, itu la title diya ase, book la title diya ase, like Constitution of India is the title of India's Constitution. And 394, commencement. At the commencement of the Indian Constitution on January 26, 1950, Articles 5, 6, 7, 8, 9, 60, 24 and so forth, all these came into force on 26 November 1949, the date of adoption. The remaining provisions came into force on 26 January 1950. Why is that? Can anyone? Now let's just take the example of Article 5. It talks about citizenship. So even before the Indian Constitution comes into force on 26 January 1950, these were required at that time. Okay. Rukyo paranai. Indian Constitution officially commenced because utuan the lagi like citizenship rules come lagi like and various other rules. 6 citizenship part 2 5 to 11 right 5 6 7 8 9 utuan lagi and other articles as well. It came into force on 26 November 1949. But exam it's just commencement. The remaining provisions came into force on 26 January 1950. When did the Indian Constitution come into force? If they ask you a question, okay, it is 26 January 1950. Even though some articles came into force on 26 November 1949, officially, if they ask you the question, 26 January 1950. That's it, commencement, 394. Authoritative text in Hindi. It was aided by the 58th Amendment Act 1987. Now, what is authoritative text in Hindi? Look at it properly. The President shall cause to be published the translation of the Constitution in Hindi, which shall be the authoritative text. Now, any Hindi translation of any amendment shall also be authoritative, which is like again our Hindi ke power bisi diya ase. Tan ko ase when the Indian Constitution was originally made, it was made in English. Okay, English language te thakise. Now, only in 1987, takan Hindi la version do utuke constitutional validity dishe and says that it carries the same authority as the English version. Utu ko ase authoritative text in Hindi. And any Hindi translation of any amendment, utu after 1987, every amendment la Hindi version bi ulai de. Which means it is not just a for namesake. It has a legal power. It has a legal authority ko ase. Utu authoritative text in Hindi do. Authoritative text do Indian Constitution la ko ase. Hindi la version do it has the same power as the English version ko ase, but nobody uses it. Kun July na Hindi la do. Kun the court pin July. The official language of the court is English. The official language of the union is Hindi. You guys remember, right? And the official language of the nation, the country is, there's no official language of the country. Okay. Article 395, repeals. Repeals means removed. So it simply states that Indian Independence Act 1947 hatai dishe, Constitution aijese de goina ko ase. Uta hatai dishe. Government of India Act 1935 pe hatai dishe de goina ko ase. All other supplementary and amending acts before the commencement of the Indian Constitution, kiman laws ase uta hatai dia ase de goina declare ko ase. That's it. Okay. Now that's the end of our analysis of Indian Constitution from part 1 all the way up till part 22 of the Indian Constitution. Now we have only 3 to 4 slides. I will not be explaining it. These are the timelines of key constitutional amendments that I prepared for all of you. Please go through it. 1951 is the first amendment. 1956 state reorganization. 1962, and I think it's important for you guys to memorize almost all of it. Okay, almost all of it. All the way up till we have the 86th amendment and 101st, if possible. Also memorize 102nd, 103rd, 104th. We also have 105th and 106th. 33% women reservation. It will be 8 code. I've kept it blank so that you guys can cover it, okay, by yourself. Since we do subset latest, all this needs to be memorized, okay. There's not a single amendment that I think isn't important, because 13 amendments, special provisions for Nagaland, we can memorize score like what. But you guys, ini huijawo, okay. Father huijawo, ini na. It might look like a lot, but father huijawo. Seasoned aspirant like me, once to don't be the level bunchile other hujan ini aru na pore de the most articles exam priority be I've kept it this way. Important articles from part 10 to part 22. Amendment procedure very high. Special status of Jammu and Kashmir since only happened in 2019. It also forms part of the current affairs as well, so it's high. Maharashtra, Gujarat law, Nagaland customary law very high. Assam medium. Manipur medium, Andhra Pradesh, Telangana. Again, Andhra Pradesh, Telangana was carved out of Andhra Pradesh. Andhra Pradesh la capital Hyderabad thakise. Holio Hyderabad to Telangana la area de thakise. Now once Andhra Pradesh was bifurcated into Telangana and Andhra Pradesh. Telangana lote it took away the capital of Andhra Pradesh, Hyderabad. Okay, Hyderabad. It's almost like eastern suburb. Usually eastern la area de Kohima thakise. Hyderabad now Andhra Pradesh la capital to Amaravati. So again, this is medium. Sikkim very low, not necessary. Mizoram again, since northeast has a medium rakhi dise. Arunachal Pradesh be medium rakhi dise. Karnataka, Hyderabad, Karnataka low. Continuance of existing laws medium. Short title very low. Commencement authoritative text repeals very low, not necessary. Just for your understanding, explain kodishe. Indian Constitution pura janiwale karne na. So again, prelims focus for this part. Mains la questions kan utungan iniga awo. Critically analyze the basic structure doctrine, compare rigidity versus flexibility of the Indian Constitution, and so forth. Okay, so at least 1 to 2 questions from part 20 every year ahead. Part 20 la, because amendment of the Indian Constitution as well. Emphasize correct. So it's very important to have this clarification of simple majority, special majority plus state ratification. These 3 distinctions. Pishi manu to distinction no grade. Pishi important. They just say, even a lot of my friends, they just know that for amending the Indian Constitution, we need a special majority. That's it. That's all they study. But you need to go a little deeper. Special majority plus state ratification, and we also have simple majority. Okay, and Article 371 is a very hot topic since 2019, related to Jammu Kashmir. So cover this as well. And 371A series is frequently asked in NPSA exams. Okay, both for prelims and for mains. 371A. Now, yeah. So if there's any doubt,